Hi, welcome to Children of Darkness and Light. Happy TGIF. Welcome to everyone. So glad you're all here. I have a little funny treat for those of you who recognize that we start on time. So you early birds who have joined us right away, here's a little something. My moderators got a huge kick out of the fact that I let slip that for several years of my life, I wore my hair very short and very white blonde, and got a huge kick out of it when I sent them a picture to prove it. So here's the proof. I once wore my hair like a Billy Idol wannabe. Welcome tonight. We have a lot to talk about. There are a lot of motions going on in the Vallow Daybell case, and also a couple things that we probably want to mention in the Brian Koberger University of Idaho case. But let's get started with the Vallow case. There's a hearing coming up next week on the 19th. I'm planning to drive to Rexburg for it, and it is a motion hearing. Will probably take the better part of the day, certainly at least the morning. And because there are a number of motions that Judge Boyce needs to hear and needs to rule on. So I want to go through each one of those motions, give you an idea of what's in the motions, and also give you an idea of what I think is going to happen. We did see in the last day or so some new filings, and I'll point those out as we go along. Most of them are objections to the current motions that are pending. So they're responses from the other side to the current motions that are pending. So let's start out with the motions that are pending for Lori Vallow Daybell, as she prefers to be called. Now, we've talked before that there were a couple of notices filed. One was a notice of alibi, and the other was a notice that they are not going to raise mental health defense. So notices are just that. They don't require any action from the court. They're just putting everybody on notice that certain things are going to happen. So those won't require any action from the judge when they have the motion hearings on the 19th. But Lori Vallow has also filed, her counsel has filed, a motion to declare the Idaho capital punishment scheme unconstitutional, a motion to declare that the defendant is not death eligible, a motion for a joint settlement or strategy session, and a motion to prevent death qualification of the jury. Now, that last motion was filed quite some time ago, but the judge has never ruled on it. So let's talk about each one of those. First, a motion to declare that the Idaho capital punishment scheme is unconstitutional. This is a common motion that is filed in most death penalty cases. It is it's a motion that gets filed in every death penalty case, and it actually goes back as long as there's been a death penalty. You may remember in the 60s and late 70s, the death penalty was declared unconstitutional as it was then, as the statute then was promulgated, was designed. So following that, then states began reinstituting the death penalty, but with some safeguards that made it constitutional, that made it fit the Supreme Court's framework for constitutionality. You can tell I'm a little tired tonight. Anyway, the biggest complaint about the death penalty as it was declared unconstitutional was the fact that defendants did not have the ability to mitigate the death penalty. So most states then instituted a two-phase death penalty structure, which is what Idaho has, which says that the first thing that happens is that the defendant receives a trial on whether or not they are innocent or guilty. If they are found to be guilty, then the second phase is to determine the punishment. And the punishment is either, in Idaho, life in prison without the possibility of parole, or the death penalty. But it gives every defendant the opportunity to mitigate the finding of the sentence of death. And in order to mitigate the sentence of death, the defendant must show that he or she has some redeeming quality, or that there is some reason that it is against public policy or good conscience to impose the death penalty. For example, in cases where the defendant is someone who is of diminished capacity, they are of a low IQ or have some other disability that causes them to be perhaps less accountable, then their attorneys will put that information on as a way of mitigating the imposition of the death penalty. So because we have seen the Supreme Court in the 70s overturn the death penalty, now attorneys, as a matter of course, file a constitutional challenge to the death penalty. So that's what this motion is. It is a sort of pro forma constitutional challenge to the death penalty, saying that across the board, the death penalty, the Idaho's scheme of capital punishment is unconstitutional. And they cite all of the usual things. It's cruel and unusual punishment. It lacks due process. They use all of the same arguments that got it overturned in the 70s. So the next motion is a little bit more individualized to Lori, because the next motion is a motion to declare that the defendant is not death eligible. So their contention is that she did not, and that the evidence is going to show that she did not conspire, or she did not, it's going to show, the evidence is going to show that she did not participate in the deaths of the victims, that somebody else did it. Once again, we have the Saudi defense, some other dude did it. And so their contention is that she did not participate in the victims' deaths and therefore is not death penalty qualified. But a lot of people have pointed out that even if she did not actively participate in causing the death of the victims, she conspired to cause the death of the victims. And in Idaho, that's enough. In Idaho, the same penalty applies whether you conspired to commit that death or whether you actually did it. So for that reason, I think that motion fails. I think the earlier motion to declare the Idaho capital punishment scheme unconstitutional fails because the judge is going to say that's a matter for the state Supreme Court and for the US Supreme Court. At this point, the death penalty in Idaho is legal. It is the law of the land. And so therefore, I'm denying that motion. I think the judge denies the motion to declare Lori not eligible for the death penalty as well because of the conspiracy aspect. The next thing is one that, well, let me talk, as long as we're talking about the death penalty, let's move on to the motion to prevent death qualification of a jury. This is another motion that is commonly filed in death penalty cases. And the argument goes something like this. If you go before a jury and you say, can you all, are you any one of you object to the death penalty? Or could each one of those jurors impose the death penalty if the person were found guilty? So the prosecuting attorney is going to explain to the jury. It's a two-part process. You have to find guilt or innocence, then you have to impose sentence. And then he will ask the jurors, he or she, in this case, will ask the jurors, if you as a jury find the defendant guilty of murder, will you be able to impose the death penalty? Or is there some reason philosophically, religiously, ethically that you would not be able to impose the death penalty? So immediately we have weeded out anyone who is not able to impose the death penalty. So the argument goes, if you have questioned jurors about their position about the death penalty, and you have already removed anybody who could not impose the death penalty, then you now have a jury that is more likely, more predisposed to impose the death penalty. So what does that mean? Well, it probably doesn't mean anything other than the fact that it is raised as another issue that could be brought up on appeals. It is a common discussion that people who are pro and con of the death penalty often have about whether or not questioning jurors predisposes them then to find and impose death. The last motion that Lori Vallow has pending is a motion for a joint settlement or strategy session. Sorry, I couldn't read my own notes. And this is an interesting motion. I don't believe that if the argument is the defendants need to sit down and strategize about how they're going to proceed at trial, I don't believe that that argument wins the day when it comes to allowing them to have this kind of a session. I don't believe that there is anything in the law that permits them to have a kind of a session to sit down and get their ducks in a row or to get their story straight. And I don't believe that that would fly with Judge Boyce. However, if, as we suspect, based on this filing, there is a plea offer on the table, that changes the complexion of this, because we would very much like, they would very much like, the attorneys would very much like to be able to get their clients on the same page about a settlement. Now, it's very possible that one or the other of them are resisting a settlement. So it's possible that one of them is inclined to settle for probably life without the possibility of parole, and another is saying, I think I want to take this to trial. So being able to have both lawyers sit down with their clients and have them have a four-way conversation about the pros and cons of settlement could be very helpful to getting the case settled. Could really mean the difference between getting it settled and not getting it settled. So it probably would be in everyone's interest to have a meeting like this. But the prosecutor does raise some reasonable questions. Now, as far as the business of you can't have a settlement conference unless the prosecutor's present, First of all, I think that's BS, because in very many cases, you have a settlement conference and the prosecutor is never in the room. The information gets shuttled back and forth by a judge, and the judge kind of does a little shuttle diplomacy, and they go back and forth, and they're never in the same room. So the very idea that you can't have a settlement conference without the prosecutor present, I think that's ridiculous. But the prosecutor does raise an interesting question, or a couple of them. First of all, attorney-client privilege is only good as long as it's only you and your lawyer in the room. The instant a third party comes in, they become a witness that can be called to talk about the conversation that happened in that room. Now, some of it may be hearsay, although in this case, it would be a statement of a co-defendant, and so would come in. But it does dissolve the attorney-client privilege. So the fact that they'd all be in the same room, Lori and Chad would no longer have attorney-client privilege over those conversations with their own lawyers, because there's other people in the room. So that in itself can be a little troubling. The second issue is, how do you do this securely? You have two people who are being held on the most serious charges. How do you make sure that the room's secure? How do you make sure that within that bubble, they are all safe? They're safe, their lawyers are safe, there's not an escape possible. So some of that may be able to be done by having them in a secure location, such as a jail meeting room, where they could all be handcuffed to tables and could all be wearing restraints. But the prosecutor is not going to want to have that happen without having a deputy in the room. And putting a deputy in the room, once again, causes problems with confidentiality and attorney-client privilege. So the prosecutor does raise some interesting questions about the logistics, just the sheer sort of, how does that work? And so it's important, if the court is going to allow this to go forward, that the judge makes some intentional and thoughtful orders about what it's going to look like when it goes forward. So those are the motions that are still pending for Lori Vallow. Now, the prosecution has a motion that is pending too, and it has actually been pending for more than a year, I think. And that is a motion to sequester the jury. Now, jury sequestration, it is an interesting and much debated idea. The idea being that you take the 12 jurors plus their alternates. In this case, it's going to be a lengthy case. We're probably going to see quite a few alternates just to make sure that there's a sufficient number of jurors to decide this case at the end. And we're going to take all of those jurors who are going to be hearing the evidence every day, and we're going to bus them down to the courthouse in the morning, have them hear the trial all day, bus them back to a hotel after court, where they will not be able to watch television, get newspapers, any of those things. They won't be able to watch TV news. They won't be able to have internet. It depends on the court how restrictive they are. But if the court restricts these folks' lives to the extent that they barely can talk to their families, that is going to be a true huge hardship on the family, on the jurors, sorry. And that is going to make it much less likely that jurors are going to want to participate. So it really is usually a last-ditch effort. It is a last ditch alternative. And I don't think we're there. I think that the admonition to the jurors, I want you to remember that for the most part, jurors take their jury service very, very seriously. They want to do a good job. They want to follow the rules and make good choices and make good determinations. So I think jurors are fully capable of following the rules. And when the judge says, don't discuss the trial, don't read the newspapers, don't read the news coverage, don't listen to TV news coverage, and don't discuss the trial with one another or with anyone else, I think jurors take it to heart and will do that. Certainly, there are always people who don't follow the rules. Otherwise, you wouldn't need criminal attorneys and a criminal justice system. But I would say for the most part that jurors really want to do a good job and that they will follow the rules. So my expectation is the judge is going to deny this one as well. So of all of the motions we have talked about so far, I think the one that could go either way would be the motion for the settlement conference. And the judge may allow it under some very limited or restricted kinds of guidelines. So before I go on to Chad Daybell's motions that are pending, I do want to say we have more than 250 people in chat right now and watching online. Thanks so much for joining us. I want to point out that our moderators who are with me twice a week, every week, all of the Super Chat donations and PayPal donations go directly to them. So if you are inclined, please hit that Super Chat button and buy them a cup of coffee or a glass of wine. I also want to encourage everybody, please subscribe if you haven't. Hit the notification bell and please hit the thumbs up because it helps us with the algorithm. But please subscribe and please hit the notification button because as the trial gets closer, we're going to be doing some impromptu or unscheduled lives, particularly once the trial starts. And if, as we believe, that the case is going to continue to have cameras and live stream banned, then it's going to be doubly important to have somebody like me who's in the courtroom being able to post YouTube shorts at every opportunity to give you an update on what's going on in the courtroom. So please, please, please do that. Michelle makes a good point. I usually like to sort of download information to you in the first half and then take your questions in the second half. We're almost to the point of questions. I do want to say we absolutely are going to end on time today. There is a Dateline program coming up on the University of Idaho murders, and I know that there's a lot of our followers who are going to want to tune into that. So we're going to finish promptly at the end of the hour, and so I'm going to go on to the Daybell motions because there's only a couple of them. I do want to point out that today we saw Daybell's attorney file a stipulated order regarding consumptive testing. Now, we've seen this before. There's been disagreements about what are we going to do about DNA testing that needs to be done and that will completely consume the sample. They've gone back and forth on this. They've worked out a way to have a conversation, worked out a plan for how that consumptive DNA testing is going to go. But the most interesting thing about this is consumptive testing for newly discovered hair. Now, where this hair's been, why the lab hadn't previously discovered it, I don't know. But they are hair samples that were newly discovered. So you can understand the defense's frustration at this point that they have newly discovered evidence that they don't have results on yet. and they are weeks away, short weeks away from trial. So it'll be interesting to see how that goes along and what happens with that. Now, as has been stated before, Chad Daybell's lawyer, John Pryor, has this pending motion to continue. That's going to be decided on the 19th. And one of his complaints is discovery's not done. And the prosecution makes the argument and counters that by saying, well, if the discovery material doesn't come in time, we won't use it. Or you can challenge it saying that you didn't have time to vet that information. So the thing that's pending is this motion to continue. And I believe that the judge is going to deny this motion. I've outlined in my newsletter why I think that's the case. I think that when the judge weighs a dismissal because of lack of speedy trial versus the possibility that Chad gets a new trial because of ineffective assistance of counsel, I think the judge is going to err on saying we're going to go forward. We're going to honor her right to a speedy trial. And if at some point he has a claim for ineffective assistance of counsel, that's going to be something that the appellate court will have to take up. I frankly don't believe that he gets a claim for ineffective assistance of counsel because of all the things we've talked about before. One of the things we've talked about before is the fact that ineffective assistance of counsel requires, first of all, that the attorney's actions be unreasonable under the circumstances. And then it also has to prove that he was damaged in some way, meaning that the outcome would have been different had he had effective counsel. I don't think that he wins on either point in an appeal. So my prediction is that all of these motions are going to be denied, with the possible exception of the settlement meeting, and that we're going to see a trial start on or before April 3rd. Now, Judge Boyce did say that he was hoping that some of the jury selection could start in late March so that the jury would be seated and be ready to start on April 3rd. So we'll see how that goes. And a lot of that probably is going to depend on Ada County and how accommodating the Ada County court can be. I've had people ask, and I've got a few questions that came in from Wednesday or from last Friday that I just want to catch up on. I've had several people ask about whether or not it's even worth it to try and sit in on any point in the trial. The answer is, I think we don't know yet, because the court has not yet released the process for how people are going to be able to get into the courthouse. The court hasn't given us any indication of what that's going to take and how press are going to be treated and what areas are going to be set aside for family and people from Fremont County. So we don't know yet. I would say it's probably going to be very challenging, and that people who want to come and sit in on a day or two of the trial should expect to be in line a long time in the mornings in order to get in. Like I say, I don't know. Sometimes they do a lottery. Sometimes they hand out passes. It just depends on court to court. A lot of it has to do with the size of the court, size of the building, all of those things. So the short answer is we don't know, but when we do know, I will tell you. I would expect that we're going to get some information about that in the next month or so. Several people, because we were talking about pleas and about the possibility that they might be considering a plea agreement, several people asked me about Alford pleas, and particularly about what an Alford plea is and whether or not they could take an Alford plea. So I'm just going to do a little quick thumbnail of what an Alford plea is. An Alford plea comes from a case with a guy named Alford who was charged with first-degree murder. The death penalty was sought, and he said, you know, I'm not guilty, and I don't want to admit that I'm guilty, but I believe the state could probably prove I'm guilty, and I want to take advantage of the deal, which is life in prison instead of death. And it was certainly a time in history when the death penalty was much more likely to be actually carried out. And so he went to court and he said, Your Honor, I don't want to admit guilt, but I will admit that the prosecutor has enough evidence to convince a jury of my guilt. And I want to take advantage of the deal. But I don't want to stand up in court in a guilty plea and admit that I did something I didn't do. So that has always been an Alford plea. It is possible for Lori and Chad to take Alford pleas. Understand this, an Alford plea is a conviction. It means I agree that the state has enough evidence to prove that I did this crime and I'm guilty. So it is a guilty plea, and it is the same as if they had entered a straight guilty plea. When you enter a guilty plea, your ability to file appeals shrinks to almost nothing. Essentially, you only have the right to appeal a guilty plea if you don't get the sentence or the bargain that you bargained for. So as long as you get the bargain, you get the deal you bargained for, your appellate rights are next to nothing. Certainly there still could be potentially some evidentiary appeals where if the court made an evidentiary finding ahead of trial, excluded evidence from trial, and then the people plead guilty because they think I can't prove my defense without that piece of evidence, the defense could go back and could challenge the judge's pretrial ruling about that piece of evidence. Then, if the Supreme Court were to overturn that decision, the defense could go back and say, we'd like a new trial because we would not have entered a guilty plea had we been able to present that piece of evidence. Hopefully that makes sense. So I had another question from Jen Chapman, and I just wanted to follow up on this one because her question had to do with a mental health plea, and whether consciousness of guilt is proof of legal sanity. And I think that's a really good question. Because the legal definition of insanity is really narrow. Now, remember, we're talking generally. We're not talking about Idaho. We're not talking about this case specifically, because Idaho doesn't have the insanity defense. And so we wouldn't be talking about this in the context of this case. But sort of as a general legal rule, because in states that allow a not guilty by reason of insanity defense, what you're saying is if you understand, if you are conscious of your own guilt and you do things to avoid getting caught, then that is proof that you're not insane. And I think in many states that is a valid argument. So to say to someone, look, if you have a backpack packed with $50 bills and a new identity, and you're trying to leave the country when you're arrested, that pretty much refutes the fact that you are insane, because you were conscious that you were guilty and that you were attempting to flee and you were attempting to cover up the crime. And I also wanted to point out that anytime there is a plea deal, the plea is for a guilty plea, which means that they are admitting guilt and agreeing to be sentenced. So anytime there's a guilty plea, that is a conviction, and that case is done. So the last question I had was, how long after trial or guilty plea before we see something in Arizona? You know, it's a good question. I think Arizona is really waiting to see what happens in Idaho. And I think that Arizona will be much more likely to make a plea, offer a plea offer if they know that Lori and Chad, Lori in this case, Chad isn't charged in Arizona. If they know that Lori is already convicted and facing life in prison without parole. So they may be more likely to make a deal and move those charges along once there's a conviction. So I want to just make a few comments about Brian Kohberger in the University of Idaho case, because I do want to leave plenty of time for questions, and I do want to end on time tonight. So first of all, there's been a lot of discussion about the fact that the defense in Brian Kohberger's case filed a motion for discovery. Now, a discovery request. Now, understand that in every case, the first thing that happens is the lawyer gets appointed, regardless of whether it's a death penalty case or not. The lawyer gets appointed, and the very first thing they do is they go into their computer and they push the button that they change the caption, and they go into their computer and they file a discovery request. It happened in every case I did, happened in every case my colleagues did. It is standard procedure to file a discovery request. In some states, it's actually malpractice not to file a discovery request, even though the prosecution has an absolute obligation to give you discovery, even without requesting it. So it is common procedure, and particularly in a complex felony case, in a death penalty case, you want to get on the record that you have asked for all of that discovery. And you are going to ask for, you're going to ask for everything you can think of. It's just a shotgun approach, right? It's just, you just pepper the prosecution with everything you can think of. And those discovery requests are just a standard form. And so in this discovery request, they asked for any statements or information that the prosecutor might have having to do with co-defendants. And everybody perked right up and wanted to know, is there something we don't know? Is there a co-defendant we don't know about? There's been no indication that there's an unknown co-defendant, and law enforcement has been pretty clear that they believe that that they have their guy. So those things could change, and I could be wrong, and they could suddenly announce that there's a co-defendant, just like they started out by saying we don't have any suspects and then suddenly made an arrest. So what we know right now is there are no co-defendants, and I think that there is I think that it is likely that that is just simply boilerplate that was part of every discovery request. In the business, we call it CYA, cover your ass, making sure that you have done your job, you have done your due diligence, for lack of a better word, and made sure that you are on record as having requested everything you can think of and then some. So Why so long until a preliminary hearing? Well, first of all, I think that the prosecution's not in a huge hurry because they still have a lot of outstanding testing and things that are going on that they're waiting for. So they're not in a huge rush. And I think there is already a mountain of discovery for the defense to go through. So, and you also have to remember that the defense are public defenders, and that it is very likely in this case that his public defender has other cases that are pending, and she's going to try her best to get those off her plate so that she can focus on this death penalty case. But for most public defenders, there's 25 or so on the death penalty, the public defender death penalty roster. And, there certainly aren't that many death penalty cases in the state of Idaho. This is pretty unusual to have two really high profile death penalty cases. Now, we don't know if Brian Kohberger's case is death penalty, and we will not know that until after the preliminary hearing and after he's actually arraigned on the murder charges. So he has been advised that the murder charges were filed, but until there is a preliminary hearing and the judge says there is sufficient information to bind him over for trial, they're not required to file their death penalty notice. So we're not going to know that for a while. But his attorney is going to be trying to wrap up other open cases so that she can focus on this case. That's going to take a while, which is probably why she asked to set it out until June. She probably has other cases and other trials on her docket, on her schedule right now. So the fact that they asked for the preliminary hearing, a 5-day preliminary hearing out in the end of June, I wasn't all that surprised. Now, Kohberger has an absolute right to have a preliminary hearing within 14 days. He waived that right in order to be able to set this out. Now, he did not waive his right to a speedy trial because his speedy trial rights don't kick in until after that June 26th hearing, that preliminary hearing. And they don't begin until the judge finds that there's probable cause to bind him over for trial. So his 6-month speedy trial window doesn't start to run until after that hearing. There was a lot of talk online that when he appeared at that preliminary status conference for the preliminary hearing, he had some scrapes and some cuts on his face. I think that is absolutely the caused by the crappy jail razors. Every one of the jails gives out these. They're a razor blade you can't make a weapon out of, and they're very flimsy and they're very difficult to navigate. And so if in fact he had nicks and scratches, I'm pretty sure that was from one of those flimsy jail unshankable razors. I'm sure that he will learn how to navigate with those terrible razors. It's just like the pens they give inmates. They're just like the ink refill out of a Bic pen with a little point on the end of it. So I don't think that it is anything for anyone to be worried about. I don't think he got jumped in jail. I don't think any of those things happened. I think they've been very cautious about making sure that he is safe in jail. And I'm pretty sure that he just messed his face up with a bad razor. So, as I understand it, the female magistrate, and I don't remember her name right now, who heard Brian Kohberger's hearing, will hear the preliminary hearing just the way that Judge Edens did in the Vallow Daybell case. and then a district court judge will be assigned. My understanding is that the judge in the district court judge in Moscow is judge, and unless there's some reason for him to be disqualified or some reason that he can't be assigned to the case. Thank you, Magistrate Megan Marshall. She will hear the preliminary hearing, and then if she finds there is sufficient evidence to bind him over for trial, which I expect, then judge will take over, and so it will be interesting to see how that moves forward. So I'm ready to take some questions. We have about 15 minutes before we're going to sign off, because I want to respect everybody's time tonight, because I know there's a lot of people who have got their DVRs set to watch that Dateline program. KCL says, would they both have to accept the plea deal, or could one take it and the other not take the plea deal? Why would Lori and Chad need to converse if there's a plea deal on the table? Good question. They don't both have to take the plea deal. But here's the thing. If one takes the plea deal and the other doesn't, the prosecution is going to insist that the one who doesn't take the plea testify, or the one that does take the plea testifies against the one that doesn't. That will be a condition of taking the plea. So, and I think that is the reason why they want to converse. Their attorneys want them to converse about the plea on the table. I think what you have is one person who is saying, I'm not going to take a plea, and the other one saying, I'm thinking about it. And I think their attorneys want to get them on the same page about a plea deal. Because if one takes it and one doesn't, the one who takes the deal, their case will be adjudicated. They will not be able to claim that they have a Fifth Amendment right not to incriminate themselves, and they will be required to testify against the other party. As it stands right now, they can't be required to testify against one another as co-defendants because they can take the Fifth. But that's off the table if one does and one doesn't. I think that's the reason why their attorneys really want to get them in the same room and really want to pin down the consequence of taking the deal versus not taking the deal. And, you know, to be honest, to humanize it, there have certainly been times when I have had clients who have been offered pleas, and I have said, I really need to have time to talk to my client about this. And my client needs to talk to their mother, their wife, their family members about what this plea looks like if they go forward. So it's not all that unusual to have. What is unusual is their co-defendants, but it's not all that unusual to have a defendant say, before I make this really weighty decision, I really need to talk to a family member. I think it's complicated and made maybe more significant by the fact that they're co-defendants, and I think their lawyers really want to get them together and explain how it will impact them if they each take a plea. So that's a good question. And plea negotiations are very, it's an art. There's an art to settlement negotiations and to counseling a client about a plea. So I certainly could see a reason why they would want to meet and talk. If it's merely a let's do a strategy session to get our ducks together to go to trial, I'd say no. I mean, I'd say, and I understand the prosecution objecting, because there's nothing in the law that allows them to do that. They get to do that through their lawyers. Dawn Schaefer. Hi, Dawn. Since Lori Vallow admitted she knew where the children were killed, can she try to plead to a lesser offense of not reporting a death? Seems that conspiracy should involve all who knew. Yeah, I don't think she goes there. I understand that there is a crime in not reporting a death. We saw that in the Michael Vaughn case, where one of the co-defendants has been arrested and held in custody on a charge of failing to report a death. I don't think so in this case. If she's going to say that she knows that the children were killed in Alex Cox's apartment, then I think that opens the door to the conspiracy charges. And certainly then the prosecutor's going to say, okay, but you knew, and you were a conspirator to it. And conspiracy can be after the fact as well, covering that up. So I hope you all have a glass of wine tonight and are enjoying our time together. We just have about 10 more minutes, and then we're going to wrap up. Gail S. says, hi, good Lori. Would you explain taking the fifth, pros and cons? Well, every person has an absolute right not to incriminate themselves. You have an absolute right to remain silent, whether it is in court or whether it is when you are talking to law enforcement. You have an absolute right not to incriminate yourself. And you can waive that right. You can decide, no, I'm going to tell the truth, and I'm going to tell what I did and what everybody else did. But you have an absolute right not to. Once that crime that you have been accused of is adjudicated, meaning that the prosecution has either said we're not going to pursue it and we're dismissing it with prejudice, or you've been found guilty, you no longer have that Fifth Amendment right not to incriminate yourself. So in the case of the Vallow Daybell case, if one takes a plea, enters a guilty plea, then the prosecution is going to want them to come and testify against the other defendant. Sabrina Holmes, question. Can Judge Boyce set a deadline for all tests to be completed so he can release the children to their family? Or is there a legal issue preventing this? I don't understand why it's taken so long. I think there are a lot of people who do not understand this. It is purely at the discretion of the prosecution. I can understand both sides of this. It hurts my heart to think about the families, and especially Kay and Larry Woodcock, not being able to bring their kids home. It's my understanding that they've asked for both JJ and Tylee, and that they be laid to rest together. It's heartbreaking that they haven't been able to do that. On the flip side, we have a prosecutor who is saying, I am not confident enough to continue through the end of this trial and possibly into an appeal without having that evidence available. I don't know why. The bodies of the 4 college students were released immediately to their families for final disposition. The only thing I can say is the prosecutors in this case know what the autopsy reports say, and they know where the holes potentially in their case are. And at this point, they are not willing to release that evidence until at least after the trial. So, because the problem is that at any point, the defense could say, we want a new autopsy by a completely new, unbiased pathologist. And at that point, the defense then wouldn't be able to produce the bodies in order to have that happen. I see both sides of it. I hope that once the trial is over, that Rob Wood will relent and Lindsay Blake will relent and allow the bodies to be released. I think that would be the right thing to do, but I'm not trying their case. So it's hard for me to know. Judge Boyce can set a deadline for all testing to be completed, and he certainly has set a deadline for all discovery to be completed, which means that any results of any testing would have to be produced before that end of February deadline. I want to say it's February 26th, but I could have that date wrong. He can say that much, but unless and until the prosecution agrees to release the evidence, it's not going anywhere. And it's really heartbreaking. Hi, Angel Don Moyer. Why do you think Judge Boyce wants the second grand jury transcript? I don't think Judge Boyce does want it, but I know John Pryor wants it. So the grand jury convened, they issued the indictments, and then several months later, the prosecution reconvened the grand jury for a day. And no documents came out of that grand jury. I can understand why John Pryor would think, what was in that grand jury? If they didn't issue new charges, is there something in there that's exculpatory? Is there something that was presented to the grand jury that led them not to issue new charges or additional charges? And I can understand completely why John Pryor wants it. Judge Boyce ordered that transcript be created and that it be turned over to John Pryor. I don't think Judge Boyce has any interest in the grand jury transcript, and I don't think he'll see it. His interest was in making sure that anything that needed to be turned over should be turned over. So we have 344 folks in chat. Please hit the like button. It seems like such a small thing that we can all do, and I overlook it all the time too. But it's such a small thing that we all can do, and it makes a huge difference in the way we show up in YouTube's algorithm. Fun to ski. I don't know. Hopeful. Fun to ski. Is that snow or water or both? Question. Can Chad come back and say that Mr. Pryor was ineffective because he is not death penalty certified, since I've had 2.5 years to do so? Yeah, no, he can't. And here's the reason why. There is no legal requirement in Idaho that a retained lawyer be death penalty certified. The requirement is that if you are a public defender defending someone on behalf of the state, you're getting paid by the state has the right to set minimum qualifications. So the state of Idaho has said, if we're paying for a lawyer, you're required to meet these qualifications. And in doing that, we consider you to be certified to take death penalty cases. But there is no statewide certification for non-public defender lawyers to be death penalty certified. It is up to the individual to interview and vet their attorney and to make sure that the attorney they have retained is sufficiently qualified to represent them. So the fact that Mr. Pryor is now saying he's bringing in somebody that's death penalty certified or that he's bringing in mitigation specialists, no, that is not going to prove that he had ineffective assistance of counsel. Sherry Long, question. Could you please explain what different types of DNA testing could or would be done on the side of the prosecution? What could they have been looking for? I'm confused about DNA testing. Okay, so I'm going to tell you right now, I'm not a scientist and I'm not a DNA specialist, but every lawyer who deals with DNA has to be at least roughly educated about it. So in really surface terms, every one of us has a certain combination of DNA. Thousands and I don't know, maybe even millions of pieces of information on our DNA strand. And that makes every one of us slightly different, even between family members, even between siblings. The only siblings that will have identical DNA are identical twins. So everybody else is going to have slightly different DNA. From that, we are able to tell, is this person related to somebody else? So in the Brian Koberger case, they were able to lift DNA out of the trash at his father's house and get a DNA sample of his father, and to say the father 99% is the biological father of the person who deposited the DNA in the Idaho murders, on the knife or on the sheath in the Idaho murders. So they were able then to use that to identify, because they had similar DNA. I'm seeing in chat right now that the Dateline program is on, and I absolutely was committed to making sure that everybody got a chance to watch that. So, Denise Hovland says there are 2 programs on about the Idaho case, one on 2020 and one on Dateline, both at 9:00 Pacific time. So I'm going to do what I said I'm going to do. I'm going to hush up. I'm going to say goodnight, and we're going to talk again. I'm going to go to Rexburg next week for the hearing on the 19th. That may mean that we don't have a True Crime Wednesday, depending on when I get there and get checked into a hotel. So I will be sure and post in the community tab if we're not having it. Brown Eyed Girl said, get your Tylee and JJ wristbands. Please do that. They're free. Send me a stamped self-addressed envelope, because I want to flood social media with people wearing them. I'm going to say good night to everyone, and I will see you on Wednesday.